Alrighty then, let's go ahead and get this started. Hopefully my microphone is working and everybody can hear me. If not, let me know and I will poke around and see what's going on. So this is the continuation of what we were talking about on Tuesday about copyrights and patents, trademarks, all that good fun stuff. So let's go ahead and dive right back in. So at the end of the day on Tuesday, I got to the Stop Online Piracy Act, or SOPA, and was going to talk about that today. So this was a bill that was introduced to expand, or its purpose was to expand the law enforcement ability to combat online copyright infringement and online trafficking in counterfeit goods. Oh, thanks. I saw that you can hear me, so I appreciate that. Um, so it was a bill which was introduced. It would have allowed courts to bar advertising networks, payment facilities, all sorts of different businesses from being allowed to conduct business with infringing websites, search engines from linking to the websites, and give ISPs or internet service providers broad power to be able to block access to websites. So you can kind of think of it as kind of a censorship idea. A lot of people were really not that happy for it. The proponents, the people that wanted that law to go into place, largely these were companies which manufactured goods and produced a lot of material and everything else, argued that it was needed for international websites. So if you remember from Tuesday, websites, well, international companies don't necessarily have to abide by copyright in the US, or if you own a copyright in the US, it's not necessarily valid in, say, Europe or Japan or China or somewhere else like that. So the proponents argued that because copyright was not global, they needed a way to protect their intellectual copyright from being compromised or being used. And the way to do that would be to block access to websites which were providing access to these copyrighted materials or selling these copyrighted goods. The opponents of the bill argued that it threatened free speech and was largely a violation of the First Amendment. It also enabled censorship. There were parallels drawn between if the U.S. was to pass this law, between the U.S. government suddenly becoming like the Chinese government, where the Chinese government controls all internet traffic in and out of China, and they have the Great Firewall of China. And so the opponents were basically saying that the US was going to have a similar situation to China, to where the government could suddenly decide that, hey, this website doesn't agree to a certain viewpoint, or some company doesn't like this website, and so we're going to block it off so nobody in the US can actually access it. Um, and a lot of websites and a lot of search engines and everybody started to complain about this. And so January 18th, 2012, the internet went dark, um, where Wikipedia, Google, Reddit, Facebook, Twitter, there were over 7,000 sites which displayed an anti-SOPA message, because all these companies were completely against this because, well, free speech violations, also advertising, and it wasn't clearly laid out how it would get blocked or who would be in control of it or anything along those lines. That was January 18th. 2 days later, January 20th, the House Judiciary Committee postponed voting on the bill indefinitely. They didn't outright kill the bill, they just postponed it. So it can still actually get passed, but that was 8 years ago, so it's unlikely that it will ever actually get passed or get reintroduced or anything like that in the near future. And if it does, people will probably complain about it like they did before. So here is a Wikipedia link to about the Stop Online Piracy Act. This was a really big deal back in 2011 or 2012. I remember when a lot of websites, and they actually have an image, a lot of websites would actually change their entire website to some message similar to this, and then basically not allow any access to the website. As an example of what could happen if this law passed. So that was what Wikipedia was. The Firefox that on their main search page when you open it, that's what it was. Other websites they would have a note saying this website could be blocked if this law passes. Some websites actually shut down for the entire day except for that notification basically saying if this passes, this is really really bad. So luckily it has not passed, but um, the corporations which manufacture a lot of goods and have a lot of copyrighted materials are always looking for mess to protect their copyright. And it's just a matter of time until something very similar to the Stop Online Piracy Act happens to come back into play. So I encourage you to keep an eye out for that. And if you agree or disagree with whatever the law is, talk to your uh, senator, congressman, and let them know. So that brings us on to copyleft. So we have on the one hand, or the right hand, copyright, and then on the left hand, we have copyleft. Copyleft is basically an extension of copyright. It's kind of a subset of copyright. Um, Copyleft is allowing anyone to distribute or modify a work you provide or work you provided, create or sorry. Copyleft is allowing anyone to distribute or modify a work provided that any derivative works or works which are created from that maintain the same copyleft. As in, if I create something and I assign it a copyleft license, I'm not talking about copyright, but a copyleft license, and I put it out on the internet, somebody can take that and then create a new product based off of what I created, as long as whatever they create is also a copyleft product and they don't apply their own copyright. So you can't change something you create from a work to your own copyright. It has to maintain the same copyleft copyright. There are exceptions and everything, but that's the general idea behind it. Copyleft allows individuals to contribute to software packages or help build onto a project or something along those lines while still maintaining control over the original project. Linux is built, it's an open source product, and it has a copyleft license, and it allows anybody around the world to write code and add on to the project um, without removing any sort of copyright type protections, because whatever they add has to also be added in as copyleft if it's going to be added to the open source project. To make something copyleft, first you apply a copyright to it. Once you apply a copyright to it, then you add certain distribution terms which allow anyone to use, modify, and redistribute the program's code or any program derived from it, but only if the distribution terms are unchanged. Now, I said program, but it can literally be almost anything. And we'll see a couple of examples of different copyleft licenses. But you have to apply a copyright, and then the copyright is basically saying, okay, now this is open for anybody to use. It's not public domain, but it is close to the idea of what public domain is. So this means that whatever you create from something that is copyleft has to also be copyleft. So I'm just restating that again. Copyleft started in the software world. Linux was one of the early ones. I don't remember what other early software packages were copyleft. I think Linux was probably the first big one, but is since to cover intellectual property created outside of the software. There's a website which we'll look at called Thingiverse, where people can design a 3D object to print and they upload it there. All those objects fall under a copyleft license. Anything that you find on that website is isn't covered by a copyright to where you have to pay the creator for it. It's all under a copyleft. So copyleft spawns several various licenses that are used today. These are three of the more common ones right now. There's a lot of different ones. They're all slightly different, but GNU General Public License is probably the most common one, and that's what Linux has as its licensing. Creative Commons, which is usually used more for created objects and artistic works and stuff like that. And then there's the MIT license, named after the Massachusetts Institute of Technology. So, the GNU General Public License. This was created in 1989 by Richard Stallman, who is a famous physicist, I believe. I think I remember that correctly. Um, the GNU General Public License grants the freedom to run, study, share, and modify software. If you modify the software under the GPL license, you have to release the source code to the public also under the GPL license. So you can't modify it, change it, and release it under a different copyleft license. The GPL specifically states it has to be under the GPL license, which means that whatever you modify is out in public, and anybody else can also modify that, provided they also release it under the GPL license. So this link is the Wikipedia link, which just goes over GPL. The history of it, it's currently on version 3, I believe. Version 3, yeah, version 3. GPL v3 is what it is. And yeah, it's interesting. I'm not ever going to test you over the actual terms or anything like that in here, but just be aware that the GPL license is out there. It was first published in 1989, so 31 years ago. All right. The next license, and this one is actually a really, really common license. It's Creative Commons, and some of you may be familiar with this. If not, well, you're going to be familiar with it after I'm finished talking about it. Creative Commons license was created in 2002 by Creative Commons, which is a U.S. nonprofit corporation. A CC license, Creative Commons, is used when authors want to give rights the right to share, use, and build upon a work they have created. Um, Unlike the GPL license, where the GPL license, you can take whatever it is, modify it, publish it. You can take it, you can sell some of the stuff using that product if you wanted, um, provided that you release whatever source code is covered under GPL. Um, Creative Commons provides flexibility for the author where they can determine whether or not they want to allow commercial use, whether or not they want to allow what's known as remixes, or basically creating a derivative work from the object. Here's the Creative Commons license from Wikipedia. Notice that the CC looks very similar to a regular C in a circle, which you would notice from a regular copyright. But Creative Commons has a number of options for it. And there's a chart over here, but you can have attribution, uh, where or attributed to it. Licensees may copy, distribute, display, and perform the work and make derivative works and remixes based on it only if they give the author or licensor the credits in the manner specified by these. Um, since version 2, all Creative Commons licenses require attribution to the creator or attributing to the creator and include the BY element. Share alike, you can distribute derivative works under a license, only under a license identical, not more restrictive to the license that governs the original work. So basically, you can create something and share it, provided that you also allow other people to take whatever you created and share it as well, or modify it. Non-commercial, basically you can't use whatever was created with that in a commercial use. And no derivative works means that somebody cannot take it and modify it and then release that. So and it can include any combination of those items there. So going from this, the most permissive is going to be up here to where it only has a Creative Commons license and then nothing else. This is the Creative Commons license where you have to indicate where you got it from or who was the original creator. And this is the who was the creator along with the share alike to where everything has to also be released under that. Non-commercial, and then there's no derivatives, and then the least open is going to be copyright. And so it allows creators to have a tiered level of how they actually want to release something. And then here's another table on what it actually allows you to do. A lot of things are starting to fall under the Creative Commons license just because it is so flexible in allowing the creator to decide what they want to have happen with their works. So, so if we look at Thingiverse, Thingiverse is a great website. If you do any sort of 3D printing or you want to look at 3D models and everything, it's a great website. People, let's see, Baby Yoda, because again, I'm a nerd. I watch The Mandalorian. This isn't a spoiler since it's been too long, but if you haven't watched The Mandalorian, I highly encourage it. Somebody created this model and released it online. And this is a 3D model that you can then take onto your 3D printer and print, or you can do whatever with it. Down here, we see the license that falls under. Now, everything on Thingiverse has to fall under the Creative Commons license. So in this case, Creative Commons, that right there is the, you have to attribute where you got it from. So there's the attribution. I hope I'm pronouncing that correctly. And then no derivative works. That's the equals. So what this means is that if you take this Baby Yoda model and you print it, you can print it and sell it to somebody because it doesn't have the no commercial. You can take it and you can re-upload it to your own website because it has that share alike, but you cannot change this model. And anytime that you use this model, you have to say who the original creator was, which in this case, where's the creator's name? Maybe up here. Yep. You have to mention Marvin Miniatures was the creator of this, but you can create that and sell what was created. Now, you might fall under some other copyright law if you happen to sell this because Disney owns the copyright and they may not be happy with you selling those in a commercial aspect. But at least for 3D created works here, you can do that. Whereas if we look at, let's go ahead and look at this and see what this license is. Notice that this one, you can do whatever you want. You can even modify it and then redistribute it. The only change is you mention where you got it from and who the original creator was. Other than that, you can take this Panther and do whatever you want with. And this is a 3D model that, and this is a 3D rendering of it, but this is a 3D model that you can take and put on your 3D printer. So that's a Creative Commons license, and it's a very popular and well common license that is used out there for a lot of things, more than just 3D printing. Now we get on to the MIT license. And so the MIT license is a permissive free software license created by the Massachusetts Institute of Technology. It's permissive in that almost anything goes with it. It puts very limited restrictions on reuse. So you can take MIT code and modify it, sell it, put it anywhere. As long as you include the MIT license with it, you're good. Um, you don't have to release the source code all the time, but you do have to conform to the licensing for that. It's the most popular license on GitHub. GitHub, for those of you that do not know, is a site to where you can put source code up there, you can work on it, you can collaborate with other team members to um, show the source code and to it does versioning control and stuff like that. It's also in use by many large software projects like Ruby on Rails, Node.js, jQuery. A lot of stuff is starting to use the MIT license. If you use the MIT license, um, a common line at the top that you have to have, well, several lines, is this, basically saying that you can do almost whatever you want with it. And it's provided as is without warranty of any kind, express, apply, blah, 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 et cetera, et cetera. Um, there's also different versions of it. And there's other variants and everything, but the MIT license is one of the most common licenses now. So, um, if there's any questions about any of these licenses or anything like that, feel free to speak up in the chat. And I have a half an eye on there. I keep glancing over and see. But one other thing about this, the GNU General Public License, um, it is a lot of Linux uses it and a lot of open source software uses it. Any company which uses a product which is covered by that, they have to release that part of the source code out to the public. So this came into play with Apple. When Apple created the first iPhone, the operating system for that, it used part of Linux and then part of code that they created. Well, anything which was covered under the GPL had to also be released to the public. And so that's why you'll see source code for some of Apple's products, but not for everything. Because anything that they created in-house, which does not fall under the GPL or some other copyleft, they can actually keep internally and keep it private. But anything that they use, which was publicly provided, basically, they have to then, even if they modify it, they have to release that out to the public so that it contributes to the public at large. So that's why some companies you'll see software out there which they have to release out to the public just because of a copyleft license. All right, now we get on to patents. So we already talked about copyrights. Copyrights cover artistic works, and they cover software and stuff like that. Patents, on the other hand, are designed for physical objects. So July 31st, 1790, Samuel Hopkins received the first U.S. patent for an improvement in the making of potash and pearl ash by a new apparatus and process. Before that, there weren't patents in the U.S. There were patents, I think, in England and around the world, but not in the U.S. Notice that this takes place after the First Continental Congress passed the first copyright law. Copyright is for expression of ideas or artistic works, and patents are for inventions and ideas. A patent gives the owner the right to exclude others from making, using, selling, and importing an invention for a limited time, usually 20 years. Now, if we remember back to copyright, a copyright is valid for the life of the creator plus an additional 70 years right now. And the life of the creator, it can also go to a corporation, and then it's the life of the creator plus 70 years, but that could be owned by the corporation. Patents, on the other hand, they're valid for 20 years. After 20 years, that patent is free for anybody to do whatever they want with it. Public disclosure is required for all patents. So unlike copyright, so I can create something, slap a copyright onto it, and I can start selling it, but I don't have to tell anybody I own the copyright to it. It's kind of implied because, well, I created it, and I might have certain documentation showing that I was the creator of this, but I don't have to go to the federal government and say, hey, I'm getting a copyright for this. Whereas patents, in order to get a patent issued, you have to create a design. And you have to write out a whole bunch of stuff, and you have to make sure that whatever it is can accurately describe what you're trying to create. And then you have to take that document, submit it to again, in the US, the US Patent Office. Then the patent office takes that design, they look over it, they check all sorts of things. They check to make sure that A, is the patent original? Does it have some sort of usefulness? Um, is it a obvious product? As in, you can't just patent a circle type of thing. We'll see a very key exception for that, but the general idea is you're not allowed to patent a circle and then own the idea of a circle or the object of a circle for 20 years. Once all that is cleared, then the patent office will give it its stamp of approval and issue the patent to the original creator. Um, yeah, so they will do that. Now, that can take years. I mean, you can create an object, submit it to the patent office, and then you can wait 5 years before they actually issue the patent. And that's why when you look at certain things on the back where it will have a patent number, they'll say patent pending, and then they will have a patent number. Because when you submit the document to the patent office, they will give you a number. And that number, if it gets issued, will be the actual patent number. The patent pending means, hey, we already did all the work. We already submitted all of this. We're just waiting for the government to come back and say, yes, this patent is issued. And so they put patent pending on any product that they create. Um, if the patent is redid, whatever was created, that patent is no longer valid because, well, that number is no longer valid, and so it's free for people to do whatever. But if the patent is issued, those objects that were created under the patent pending are covered under the original patent. So that company owns it. That's why you'll see patent pending on a lot of stuff. Once it's actually issued, then they typically change patent pending to patent and then list the patent number. So there's two different types of patents. There's design patents and utility patents. Design patents cover the ornamental, non-functional design of an item, and they can be invalidated if it has a practical utility, such as the shape of a gear. Ornamental, non-functional design is basically how something looks or how an object may um, not necessarily function, but it's the layout of how the object will be. Um, if you look at patents for cell phones, the design patent is going to be how the phone is laid out, the shape and the color and all that sort of stuff. Whereas utility patents cover the way that an article is used and works. And those are going to be something like if you create a new doodad and that doodad has a bunch of parts on the inside of it, a utility patent will cover the actual internal workings of it and how everything all fits together. So if going back here, I mentioned that your idea would have to be original, have usefulness, not be an obvious product. And I used the example of I can't just patent a circle. Well, Apple ended up having a patent issued for a rectangle. They currently own a patent for the design of the first iPad, and it's the design patent, so it's just the overall layout of it, not the actual functionality. Um, but part of that is the shape of this, and this happens to be a rectangle with rounded corners. So if we look at this particular patent, and I believe that, let's see, it's been, oh, this is the actual patent site. I think this will take me to it. Yeah, so this is the actual patent in question. And if I zoom in here, um, ornamental design for an electronic tablet as shown as described. And this is, oh, this is Microsoft. This isn't Apple. Which one was I on? This is Microsoft one. Maybe I clicked on the wrong link here. Um, ah, this is the actual patent. So this is coming from patents.google.com, and this is just Google aggregating everything and releasing it to the public. Um, but if we look at, let's see, clicking on the PDF, this is the actual patent. This shows the inventors, the assignee, Apple Computer. The claim an ornamental design for an electronic device substantially as shown and described. And so here you have the actual layout of the iPad. Now, Figure 9 is exemplary design of the use of the electronic device. Therefore, the broken lines being shown for illustrative purposes only and form no part of the claim design. So if we look down at image or Figure 9 and we zoom in, this shows a person using it, and notice that the only solid line is going to be the shape of the rectangle. Everything else is not. So this patent that was issued um, is just for a rectangle with rounded corners. Somehow the patent office still managed to issue that, and it was valid. Apparently the application will expire April of this year. Oh, actually April 2nd. Oh, I guess that just expired today, which is news. But you can see that this was filed back on the 17th of March in 2004 and was granted May 10th, 2005. And so this was valid for 15 years before it apparently expired. So Apple they did own the patent for a rectangle with rounded corners. And then this right here, this is another patent. And again, because I'm a kind of a nerd, this is the first patent that was issued for the design of Yoda from Star Wars. And so if we actually look at the PDF, we can see that the inventor was George Lucas, Ralph McQuarrie, who was the artistic designer for Star Wars, Joseph E. Johnson, and Stuart Freeborn. And they were all involved in the original Star Wars, assigned to Lucasfilm. So the term was for 14 years, filed in April 18th, 1980. And so here you have the original design patent for Yoda, because, well, Yoda's cool. It's not green. They mentioned the colors somewhere in here. I do not see a color designation. Some patents I think will probably list a color for that, but they may not be required. And there's several other patents out there. Those are just two notable ones. Your homework assignment will actually be to find or think of an idea and then see if there's a patent out there for it. You'll be surprised at how many different patents there are. There's quite a lot. Now we get on to trademarks. So trademarks are words, names, symbols, or devices used in the trade with goods to indicate the source of the goods and to distinguish them from the goods of others. A trademark is basically the name Walmart or the name Samsung or something along those lines, including the design of their logo. Those are filed under a trademark. Um, Trademarks are really, really important in the world because, well, you don't want to have two companies with the exact same name and the exact same logo. That would cause a lot of confusion. Trademarks cover the use in a specific industry, so different companies or individuals can own the same trademark in covering different business types, provided that they're not quote unquote famous. There's always the exception to the rule. So the example that I have is Nissan Computer versus Nissan Motor Company. So if I do a search, so if you wanted to buy a car, let's say you want to buy a Ford, Ford.com will take you to the Ford website. It's kind of slow right now. There we go. Or if you wanted to buy a Toyota, Toyota.com. That will take you to the Toyota website. You can probably extrapolate where I'm going with this. But let's say you wanted to buy a Nissan, Nissan.com. that does not look like the Nissan website. And in fact, this is a individual guy by the name of, I think, Yuri Nissan, URI Nissan. I think he's from Israel. Um, doesn't show a name there, but um, he uh, he has a last name of Nissan, and he started up a business repairing computers, Nissan computers. Um, and in fact, you can still find some of the services here and everything, in-house computer repair, $50 per hour. But anyway, he created this website back in 1994. Nissan Motor Company, they decided that, well, this was kind of the big dawn of the internet. The internet kind of existed before that, but it wasn't nearly as popular. Back in the mid 90s is when a lot of people um, started to get an online presence, and a lot of companies started to. Well, Nissan Motor Company, they decided that they wanted to have Nissan.com. And they go checking, and suddenly they see a website up there for this guy who is repairing computers. Well, they didn't like that. They wanted to have Nissan.com. So they filed lawsuits. And lawsuits went back and forth. You can read through all this and everything. It's kind of interesting. But eventually the judge sided with the original owner of Nissan.com, because the guy who owns Nissan.com, he didn't create it or didn't purchase it just to spite Nissan Motor Company, or uh, run a anti-Nissan webpage specifically because it was Nissan.com. No, it was his business and his last name. He owns his last name, so he can actually have the website. And so Nissan Motor Company, they lost, and that's why if you wanted to buy a Nissan, you don't go to Nissan.com, you go to NissanUSA.com, and that will take you to the actual Nissan website. Um, I know that they are still not very happy about it, and you can tell that the owner of this website is not happy about it because, well, anti-Nissan links. Yeah, Uzi Nissan. That's what it is. His name is Uzi Nissan, born in Jerusalem, Israel. Um, so they aren't happy about it. This guy's not happy about it. I mean, he's happy that he won, but it cost him a lot of time and money, and a lot of lawyers were involved, and he ended up winning. Um, but that brings up cyber squatting. So, with the advent of the internet, cyber squatting caused a big, big problem with trademark disputes. So, a lot of people, a lot of enterprising individuals decided that they would try to buy domains before a large corporation could. So imagine Microsoft.com wasn't actually Microsoft, but I decided to buy Microsoft.com before Microsoft could actually get on there. Um, and this worked for a bit. And so what people would do is they would buy these domains, hold on to it, and then when a company um, decided that they wanted to be on the internet, they would have to go to the person who owned that domain and say, "Hey, we really really want this domain. This is our business. We're offering to pay you some money." And sometimes money would exchange hands, and they would own the domain. Other times, companies really didn't like that because they would see it as kind of a trademark violation. And so they would basically sue the individual, saying that, hey, you bought this for the sole purpose of extorting money out of us, cyber squatting. We're going to take you to the courts. And the courts have started to agree with the corporations out there and the companies out there, basically saying that if you buy a domain and you don't have a business purpose, or you don't have a need for it, if you're buying it specifically for um, reselling it to a company, then we're going to just transfer ownership to the company. We aren't going to allow you to extort money out of the individual company or business or something like that. And I believe that Congress has even implemented certain laws which basically make it illegal to buy a domain for the express purposes of um, taking it from some other company. Um, and so with that, cyber squatting isn't nearly as lucrative as what some people had for it, but there are still some instances where somebody buys a domain and they own the domain for a while, but then some company comes along and they want the domain. Well, there's certain exclusions to it, and the domain may not change, but sometimes some companies can force an individual to give up a domain. The other thing about trademarks, which I don't actually, oh, I do have it on the next one, so I'll talk about that in a minute. So that basically covers trademarks. Now we get onto infringements. So infringements on patents, trademarks, and copyrights are typically country specific. So if you are in, say, Japan and you create a product, manufacture it in Germany, and then sell that product in, or manufacture it in China, turn around and sell that product in Europe, you can find out that whatever you created infringes on a patent in Germany because Japan doesn't recognize that patent, China doesn't recognize that patent, but Germany does. And so you would not be legally allowed to sell it in Germany, not without paying the original patent holder some amount of money. Um, then that's the same for in the US because you can own a patent in the US but not own the patent in Germany, much like copyrights. You can own a copyright in the US but not own the copyright in some other country. Um, Patent infringement is largely a civil matter, and that's part of the reason why so much patent infringement exists. The main causes for it is in order to get a patent, you have to create a design and then send it off to the patent office, and then those get publicly published, including with sometimes exactly how a product is created and how a product functions. And because of that, somebody can just download that patent and then go ahead and create their own copy of it. And that's why you'll see a lot of patent infringement happen in foreign countries because the patent exists in the U.S., but in other countries they don't have that patent, so they can go ahead and do whatever they want. Also, it's largely a civil matter. So if I was to create something and somebody else was to take my copy of the patent and create their own thing, let's say some larger company, um, I can't go to the police and say, hey, they stole my design, go ahead and force you to give me money. Because the police will just say, well, there's nothing we can do. It's a civil matter. What you have to do is you have to then sue the company or and go to the courts and basically say this company or this individual is infringing on my patent. And the courts have to look at it, see who owns the patents, see who's actually infringing, and then determine what damages there are. A lot of times, if it's a clear cut, this company completely ripped off a valid patent, then the courts will say, okay, this company has to pay you damages and they have to pay you X amount for each object which is sold or everything like that, or they're not allowed to sell that, anything along those lines. Um, if it's between individuals, it's a little bit harder, and if the patent is generic enough, then it you run the risk of the patent get validated because the courts are able to say, yes, you own a patent, but it's too generic. This has to go back to the patent office and they have to look at it. Or the company that is infringing on it can go to the patent office and say, hey, this is too generic. This shouldn't apply anymore. And that's part of the reason between Apple and Samsung. Samsung, um, their early Galaxy phones looked an awful lot like a Apple phone from the design standpoint. And Apple sued Samsung for uh, quite a lot of money for um, copying their patent and copying their designs. And the case has been going on for quite a long time, and I don't even remember exactly who won, if anybody won, other than again the lawyers. The lawyers always seem to win, but I know at one point Samsung owed Apple a lot of money. At another point, Samsung didn't owe Apple any money, and then I think a patent for Apple's got invalidated, and it went back and forth, and it's a huge mess. But Apple sued Samsung for that because, well, they Apple feels that Samsung infringed on their patent or their design patent. But again, because it's a civil matter, the police didn't get involved, the FBI, and they didn't arrest anybody for it because, well, it's not a criminal matter. Trademarks, on the other hand, they have to be constantly used and infringement aggressively litigated. Otherwise, the company could lose the trademark. So a patent is valid for 20 years. After 20 years, the patent's no longer valid, and anybody can do whatever they want with it. Trademarks, on the other hand, I believe that they're valid for the life of the company. Um, and if anybody tries to use a trademark, you have to sue them and you have to aggressively fight the use of your trademark. Because if you don't, then you run the risk of losing that trademark because the courts can say, well, what about this instance last year where you knew that somebody was using your logo and you decided to not do anything about it? Why are you suddenly suing this other individual for using your logo? Why not that first individual? And so that's why a lot of times you'll see a lot of trademark disputes and a lot of companies go after the actual trademark because if they don't fight it, then they run the risk of permanently losing that trademark. And for really large companies, it'd be really bad if, say, Walmart lost the use of the Walmart logo and the Walmart name, and somebody else was allowed to use it. Um, so this website here, Secure Your Trademark, it's interesting. 71 notorious patent, trademark, and copyright infringement cases. Um, I encourage you to go through these and look at it, like 13 ludicrous celebrity trademark studies or stories. I think it was, yeah, Paris Hilton successfully sues Hallmark for infringing on her quote unquote "That's Hot" trademark because apparently she owns the trade for "That's Hot." Boise State University owns the exclusive right to use a blue turf on a football field. That's why you'll never see a blue football field, and we're talking about American football, or as the Europeans like to say, hand egg ball. But anyway, that's why you'll never see another football field which is blue anywhere else, at least in the U.S. Harley Davidson attempted to trademark the sound of a Harley's engine revving. Um, let's see. Facebook owns a trademark for the word face. Um, Donald Trump's failed attempt to trademark his catchphrase, "You're fired." Um, yeah, so there's those, and then there's also, was it this one? Yeah, 11 insane examples of trademark lawsuits. So Monster Cable, they make high-priced and, well, probably, frankly, overpriced cables to hook up audio systems and video and stuff like that. Um, Monster Cable and Hanson Beverage, they make the Monster Energy drink. They both think that they should own the rights to the word monster, so nobody else would be able to use monster. KFC tried to claim ownership of the phrase family feast. Some of these they are still valid. Some of them were just the company didn't agree with it, and so they wanted to um, try to own the trademark or own the rights to it. Um, but yeah, so there's this website. They've changed the layout. Yep, it was updated a couple of days ago. And some of these are interesting. I encourage you to read through some of these. You don't have to read through them. I'm not going to test you on all of it or anything like that. But yeah, so some of those are rather interesting. And then this link here is explaining why patent infringement is fairly common. Yeah, that's my last slide. Why patent infringement is fairly common, and it's because there's a lot of reasons for it, and I already detailed most of them. Um, the one last thing on trademarks I wanted to touch upon is let's see, I think it's on the Wikipedia. I should have just trademark Wikipedia trademark. I think this actually has an example of, yeah. So the operating system Linux, that's a trademark, but you'll notice that there's also laundry detergent, which has the name Linux. And because those are two separate industries, they can each have their own trademark. Linux is not allowed, the software foundation that owns Linux is not allowed to make laundry detergent and sell laundry detergent under the name Linux. The laundry detergent company, Linux, is not allowed to make and sell software named Linux. And because of that, these two companies, they can coexist peacefully and separately without infringing upon each one. Product bearing the Linux name, but not infringing the trademark owned by Linus Torvalds, the creator of Linux. So um, that is pretty much everything I have for this. If there's any questions, I haven't seen any questions, so hopefully I've been explaining it excitingly enough for everybody. If not, well, hopefully you don't get keyboard face where you fall asleep on your keyboard and you get the indentations on the your cheek and everything else, because that's kind of embarrassing to explain to somebody else. Um, Next week we will be talking about cybersecurity, which is actually really exciting, and I kind of wish that we would be in person because I have a bunch of cool things to show you, but I'll make do with these online videos. Um, I don't know if it cut off my stream on Tuesday at the end. I may have cut off the last couple of minutes of my stream. If it does cut it off, let me know and I'll figure out what to do not get it cut off. Again, this is my first time actually streaming this, so there are bound to be hiccups. But yeah, so I will have the same class next Tuesday and Thursday, same time, where I will talk about cybersecurity topics. So there's no more questions or anything. So I will go ahead and let's see. I will go ahead and end this now. And thank you for watching.